The answer is yes, with court's approval. So the debtor can certainly incur a new debt. A simple example, let's say in an individual case, the debtor wants to buy a car because the old car is given out. Well, the debtor can certainly buy a car and incur debt, but it has to be with the court's permission. So we'd file a motion for authority to incur debt. And there is in section 364 of the Bankruptcy Code sort of a four-part way in which to incur debt. If you can get unsecured debt, great. If you can't, you may have to get secured debt. And all of that has to be done with the court's permission. Because remember, if you're starting to incur debt, you are putting some of the assets of the bankruptcy estate on the line. And so the judge has to be convinced that this is a good idea. And the creditors, of course, can chime in if they feel that the motion for authority to incur debt is unjustified, it's unreasonable, and it's prejudicing their rights. But yes, the debtor can incur debt and can obtain credit. But again, everything has to be done with the permission of the bankruptcy court. There is a certain paternalism to this, I freely admit, but the idea here is, number one, to protect the interests of the creditors, and number two, to increase the likelihood of success in the plan. Because a lot of Chapter 11 plans don't succeed. In fact, a lot of Chapter 11 cases never even get to plan confirmation. So the idea behind this oversight, at least in part, is to protect the interests of the creditors and to ensure success, or at least to increase the likelihood of a successful case. In sum, yes, you can do these things, but you must get the court's permission.